Today on the podcast, we're going to talk about a really controversial thing in the law, and it's pain and suffering. What it is, who receives it, and how it's evaluated. So if you want to learn more about that, stay tuned. Hi, I'm Michael Coker, a personal injury lawyer in Lawrenceville, Georgia. And today we're going to be talking about one of the more interesting and even somewhat controversial topics in the world of personal injury law, and that is pain and suffering. Pain and suffering is an item of what's called tort law. Now, tort law is just an example of when someone causes an injury or someone causes damage to you. In our American justice system, you're entitled to compensation for what you went through. And this has been around since our founding fathers created basically our legal system in the United States. And tort law has many different aspects of it. Now, the most common type of tort case is called a negligence case. And a negligence case is when somebody else does something basically improperly and causes injury or damage to another person or their property. They're responsible for the damage that they cause. And when you hear about these personal injury cases, these are mostly negligent type cases. So these are cases where it deals predominantly with the aspects of someone does something, someone is negligent, and therefore they're liable to that other person for those damages. Now, on another video, we'll talk about some of the other damages that you can receive, compensatory damages, punitive damages. But one of the items of damage that you're entitled to is something called pain and suffering. Now, pain and suffering damages is basically determined by what is called the enlightened conscience of a fair and impartial jury. Now, what does that mean? I mean, that's a bunch of legal speak. It's what our law says. But what does that mean for you? So if you have an injury, if you're in, for example, a car accident, motorcycle accident, you're hurt at work, for certain types of cases, maybe it's somebody else's fault, not your employer's fault, and you're entitled to pain and suffering. How do you determine what that is and what goes into it? And the big answer is that nobody really knows, because as the law says, it's up to the individual jurors to determine what amount is proper for pain and suffering. Now, there's certain things that lawyers do, certain legal tricks or things that are done at trial to determine how much that should be, but really it's up to the jury at the end of the day, and the idea is that a jury of your peers should determine the value of what you went through, of your pain, of the suffering, of the injury itself, and how much that you receive. Now, one of the best ways to think about pain and suffering is a little trick that many lawyers do, especially at a trial. And that's basically to determine what amount should you receive if this were in a classified ad. Now, this is an old legal trick that lawyers use sometimes basically to kind of make a jury more adequately understand what pain and suffering damages should be. So if you were to imagine that there was a classified ad in the newspaper, and it was seeking a person to take a position, and that position was to go through all the physical pain that you've been through, to go through the mental pain and anxiety that you had went through, and for all of the surrounding circumstances that dealt with your pain and your suffering. What amount of money would you assign to that classified ad to basically make it worth the person to take that job? So when you think of it in those terms, it makes it a little more concrete, right? So if you have a case and you have pain and suffering damages, think of that classified ad. Okay, if you were to sit down and write out all the things that you'd been through, maybe like the fear of the extent of your injury. That's a big one here in Georgia. So you're sitting there wondering, how bad is this really going to be? How many surgeries am I going to need? Am I going to deal with this for the rest of my life? You would write that in the classified ad. The shock of the impact, that's another big one. How shocked are you, or how concerned are you that this is going to forever change your life, right? There's other aspects like diminished capacity to labor and earn money. So if you're somebody who prides yourself on working hard and being a part of being a productive citizen who has a job and who works very hard and who tries their best to earn money, how much are you going to lose that self-worth not being able to do that? Both mental anguish, right? I mean, obviously, we all know that physical pain is one thing, but sometimes the worst aspects of a case are really the mental pain and the mental anguish that you go through after you ultimately receive a particular injury. And so these are all aspects of a personal injury case that you need to be aware of and you need to understand are all a part of that pain and suffering. So I would encourage you, if you have a personal injury case, whether you have a lawyer or you don't, and you're trying to figure out what amount makes sense for my kind of pain and suffering type case, sit there and list these items out. List out the effects that it had on you mentally, the time that it took for you to feel better, the stress of wondering how this is ultimately going to affect or change your life. Make a list and write these down and imagine a classified ad and now say, okay, if I were in the newspaper and I was looking for a job to get paid, if I was looking for some way to make money and I saw this classified ad, what amount of money would I need to fill in that blank on that classified ad in order for me to take that position? And that's just an easy way to kind of make this kind of obscure concept of enlightened conscience of a fair and impartial jury and put it into a more concrete basis of understanding, okay, well, what does that really mean? Now, I think this goes both ways, right? I mean, there's people who have serious, serious cases who it would take millions and millions of dollars for people to consider, yeah, like if I'm going to take that, like I'm going to need millions and millions of dollars to deal with that level of pain and suffering. But it can also be a reality check for you as well. That if your case is not worth millions and millions of dollars, right? If the pain really hasn't been that great, if it really hasn't been this huge disruptor of your life, if there's not this mental anguish and anxiety associated with surgeries and recoveries and this or that, it might also be a reality check for you that maybe this case is not worth as much money as you think it is. Because when you sit there and you look at that classified ad, there might be somebody out there that will take your life or take your position in order to receive the amount of money that you post. And so I think it's a good tool that you can use on both sides of the case, both to basically take a look at your case and say, hey, is this case worth more for pain and suffering than I realize? Or even a dose of reality is this case worth less than I realize? Because when I look at it from a classified ad standpoint, there's a lot of people hurting, there's a lot of people suffering, there's a lot of people that maybe would be willing to change lives with you to take that life in order to get X amount of dollars. And so that's kind of one way that we use to basically kind of quantify things. The other way that a lot of juries or a lot of lawyers use is they use what's called the per diem method to determine pain and suffering. Now, pain and suffering via the per diem method is kind of a legal thing that's done for juries, particularly to give juries who are very analytical and who are very numbers-based, something that can kind of base their amount on, right? Because when they hear, you are to award pain and suffering the amount of a fair and impartial jury, they don't really understand what that means. And so basically what you're doing is you're assigning a daily cost for that pain and suffering. And so you can take that amount, like let's say, and it needs to change, right? Because your pain changes. Let's say maybe right after an accident or an incident, your pain is at its greatest. In those situations, you deserve the most amount of money, right, per day. And so maybe we assign for the first 60 days, that's when you were in the most pain. Maybe we assign a certain amount of dollar value for those days. You could either do it one of two ways. You can do an hourly rate or you can do a daily rate. That's one way. Then maybe after that 60 days, maybe after that, maybe for the next 6 months, maybe you're doing a little bit better, but maybe you're still not healed. And so you may assign a different amount for those days. And then maybe this is something that's going to continue in the future. Maybe in the future, you're going to continue to have problems. You have a doctor who's verified that you are going to continue to have these issues, you're going to continue to have these problems. And so maybe in the future you pick an even lower amount because, you've got your pain managed now. Maybe you're taking medication, maybe you're doing periodic injections, but it's managed. And so you would take that daily value and look into the future. And so again, when you take these values and you add them up and you go do the math, do your homework and say, hey, these are the amounts that I think we should receive for these days, and then this amount for these days. And then you come up with a total value that is going to be your ask or your request for either the insurance company or the jury to award you for your pain and suffering. So the per diem or the per day method is another way for you to kind of get a grasp of a hard number of what amount or what value can you receive for pain and suffering for those days. Now, neither one of these methods is the tried and true correct method, right? These are just tools that lawyers have come up with to allow juries or insurance companies to understand what that value might be. But again, at the end of the day, it's up to the jury. It's up to what they feel is appropriate, what they feel is best for your particular case, and to use that amount and to award you that amount for your pain and suffering. Now, there are a lot of people ask me about emotional distress. And Georgia does allow you to receive damages for basically infliction of emotional distress. But in many cases, in order to receive damages for emotional distress, you also need to receive some sort of physical injury. So if you're just standing there and you watch a car accident happen, for example, and you're standing there, maybe you're eating an ice cream in an ice cream cone, and you're sitting there and you see this horrific accident happen. In many states, that you cannot recover injury for emotional damages unless you also suffer some sort of physical damage as well. So that's one thing to keep in mind. So we do get a lot of calls about emotional distress damages, and that's something that, again, is relevant when you suffer some sort of physical injury as an element of pain and suffering. But sometimes it's difficult to get emotional distress damages without some sort of physical injury involved. Now, there are some exceptions to that rule, so it's not always the case. But generally, it makes it a lot more difficult if there's no physical injury. So that's a little bit of a review about pain and suffering, what it is, and who receives it. So anytime you suffer any sort of physical injury that someone else is at fault, you definitely need to consider pain and suffering as part of your case. An insurance company's probably not going to tell you about this. They're probably just going to say, hey, send us a copy of your medical bills. We'll get them taken care of. Send us the amount of time you missed from work. We'll pay for your lost wages. And often adjusters will not bring up the pain and suffering in a case unless you specifically ask for it, you specifically account for it, and you come up with some system to support or show them why your valuation is correct. Another thing you could do is if you have a very good and experienced lawyer, they're going to know what values of pain and suffering are reasonable and unreasonable given your specific case. And they do this through what's called verdict research. So they look at past cases, both their own cases and other cases, other attorneys who have had cases in the area, and they kind of say, okay, well, your case is very similar to this case that happened, whatever it is, 2 years ago, 5 years ago, last year, whatever it may be. And they say, okay, we think that your pain and suffering falls in this range based on historical trends of juries. So if your attorney can't give you these historical trends, or maybe they don't have enough experience with personal injury cases to know what these trends are, how can you actually know that what you're getting for pain and suffering is fair? So I would always encourage you need to talk to a lawyer who is experienced, who has that experience, who's tried cases, and who has this historical knowledge to be able to tell you what you should receive or should not receive for a pain and suffering case. And trust your lawyer. Trust that experience. Trust that what they're telling you is that they're going to get you every penny they can. All of my cases, for example, are on a contingency fee. So that means we take a percentage of the settlement. So you don't ever have to worry about paying me anything out of your pocket. But that also incentivizes me because every dollar I get for you, then that's more money for me as well. So we're going to get you every penny we can. But you can rely on my experience and other attorneys' experiences about who know what they're doing and can give you an actual and accurate assessment of what a proper range is for your pain and suffering case. So if you have a case and you're contemplating what your pain and suffering might be valued at, I would encourage you, give me a call. It's a free consultation. I'm more than happy to talk to you about it, give you my opinion of what your pain and suffering's worth before you settle, before you make a major decision and might be leaving money on the table, okay? So if you have any questions, feel free to give me a call. And if you like getting these updates about Georgia law and what's going on, feel free to like and subscribe and keep on watching. Thanks for listening, and we'll see you next time.